Welcome to This Explainer. Today, we're diving straight into a fascinating and honestly deeply sobering journey through the justice system. We're looking at the case of Bongani Norman Mnguni, a man who found himself literally fighting for his life from behind bars. We're going to rely strictly on the official constitutional court records from 2005 to explore this massive legal clash. Because at its core, this is a story about what happens when the cold, unbending nature of strict procedural law collides head-on with the urgent, undeniable need for human dignity. Let's get right into the foundation of this whole case. To die a consolatory and dignified death. Now that phrase right there, that's not poetry. It is pulled directly from Section 79 of South Africa's Correctional Services Act of 1998. This specific law sets an incredibly profound literal life or death threshold. It basically says that if a prisoner is diagnosed as being in the absolute final phase of a terminal disease, they can be considered for medical parole. The whole intent of the legislature here is pure compassion, right? Giving someone the chance for a dignified end outside of prison walls. And this legal standard is exactly what our subject was desperately trying to meet. Part 1. Medical plea. A prisoner's request. Okay, let's lay out the stark reality of Mr. Mnguni's situation. He was serving a 15-year sentence at Leeuwkop Medium A prison. And while he was in there, back in 1998, he received a totally devastating diagnosis, HIV-AIDS. Fast forward to 2004, and the news gets even worse. His doctor tells him his CD4 blood count had absolutely plummeted to below 200. Medically speaking, his immune system was severely compromised. He was incredibly vulnerable. So, faced with this grim reality, he applies for medical parole under that Section 79 we just talked about. But here is the critical detail you have to keep in mind. He navigated this intensely complex, high-stakes system entirely on his own. No lawyer, no legal assistance whatsoever. And his initial application? Completely unsuccessful.
Part 2. The High Court steps in.
Realizing he was totally out of options at the local prison level, Mr. Mnguni made a move and approached the Johannesburg High Court. And what's really fascinating here is how the High Court reacted. They didn't just bang a gavel and say, release him immediately. Instead, on June 8th, they instituted a highly structured intervention. They basically set up a ticking clock, a strict multi-step mandate to guarantee a proper, fair evaluation. We've boiled it down to 3 major milestones. First, a mandatory medical exam at Johannesburg Hospital by June 23rd to get an objective baseline of his health. Next, an interview with the Case Management Committee by July 14th to review his behavior and any potential risks. And finally, a parole board review meeting by August 2nd for the ultimate decision. It was a perfectly clear, court-mandated path.
Part 3. A sudden, bureaucratic roadblock. But then, he hits an absolute brick wall. This is the stark conflict at the center of everything. You've got the High Court demanding this careful, step-by-step review. But then, on July 4th, Mr. Mnguni sits down with the Case Management Committee, the exact people supposed to be carrying out Step 2 of the court's order. And instead of interviewing him, they just abruptly drop a bombshell. They tell him point blank that prisoners are no longer released on medical parole. Boom. Just like that. A blanket refusal that completely derailed the High Court's careful timeline.
Part 4. The direct access rule. So, what do? You're sick, you don't have a lawyer, and the bureaucracy just slams the door in your face, completely ignoring a court order. It brings us to a huge legal question. Can a prisoner just bypass all the normal appeals, skip the line, and jump straight to the highest court in the land? Well, legally speaking, there is a mechanism for this. It's called direct access, governed by Section 167 of the Constitution and Rule 18. And it's exactly what it sounds like, going straight to the Constitutional Court. But there's a massive catch. It is tightly, heavily restricted, granted only in truly exceptional circumstances. Think about it. If they let everyone jump the line, the highest court would totally collapse under the weight of first instance trials. They are an appeals court, so the legal bar you have to clear to prove your circumstances are exceptional is incredibly, astronomically high. And you really get a sense of the sheer urgency here when you look at how fast everything moved in mid-2005. June 8th, the High Court order. Less than a month later, July 4th, the Prison Committee effectively defies it. And by September 26th, the Constitutional Court is already handed down a final judgment on his request for direct access. I mean, the legal gears were grinding at absolute top speed for a terminally ill man desperately seeking relief. Part 5. A nuanced final verdict. So, what did the Constitutional Court decide?
Well, sticking strictly to the procedural rules we've just talked about, they impartially ruled that Mr. Mnguni simply did not establish those exceptional circumstances required by Rule 18. The 9 judges looked at it and, as a matter of pure law, they officially dismissed his application for direct access. Despite his dire health, the legal threshold to bypass the lower courts just wasn't met.
It sounds like a totally crushing absolute defeat, right? But hold on a second. We have to ask, did the highest court in the land really just look at a highly vulnerable, unrepresented, terminally ill prisoner, stamp his paperwork denied on a technicality, and just look the other way?
Actually, no, not at all. This is where the judgment takes an incredible pivot. The court added this directive. The registrar is directed to draw this judgment to the attention of the Law Society for the Northern Provinces with the request that it consider whether to appoint an attorney to consult with the applicant. The judges basically said, look, we can't break the rules to hear your case right now, but being denied medical parole despite a high court order, that is way too important to ignore. They knew he couldn't formulate a proper legal claim alone, so they actively stepped in and essentially tapped the Law Society on the shoulder to get this man a lawyer.
And honestly, what you really should take away from this explainer is a profound lesson in how the justice system actually functions. Yes, courts are rigidly, strictly bound by procedural laws. They literally can't just break their own rules, even for the most sympathetic cases, because that would break the entire system. But within those rigid boundaries, they can still exercise pragmatic compassion. By actively looping in the Law Society, the Constitutional Court made sure that a highly vulnerable citizen would finally get a fair fight. It proves that justice can remain accessible, even when the front door is technically locked.
So, to wrap this up, I want to leave you with a provocative thought to chew on. When we look at Bongani Norman Mnguni's fight, we're watching a system desperately trying to reconcile cold, hard procedure with raw humanity. How does a society perfectly balance the strict, unbending letter of the law with the urgent human necessity of a dignified life and a dignified death? It's a massive question that judges, lawmakers, and all of us really have to continually grapple with. Thank you so much for joining me for this explainer. Keep questioning, keep learning, and I'll catch you next time.